It alleges that you have violated the terms and conditions of your probation in 3 ways. Count 1 is that you allegedly violated condition 2.4 that requires that you must not use or possess controlled substance or drug paraphernalia. And more specifically, it's alleged that on or about March 7th of 2025, you possessed a pipe commonly used for smoking methamphetamine. Count
No.
2 is, hold on, Miss Rourke, let me just tell you what the hold on. Let me just tell you what the allegations are first. Then I will turn to you and we'll talk. So just let me, I have to get through telling you what the allegations say first. Count 2 alleges that you violated condition 2.0 that requires that you must not use or possess alcoholic beverages or other intoxicants. And more specifically, it's alleged that on or about March 7th of 2025, you possessed alcohol. Count 3 alleges another violation of condition 2.4, which again requires that you must not use or possess any controlled substances. And more specifically, it's alleged that on or about March 7th of 2025, you used methamphetamine. Was that the result of a drug test, Mr. Stapleton?
Yes, it was.
All right. Now, Miss Rourke, you have the right to challenge these 3 allegations at a contested hearing. That hearing would occur within 14 days from today's date. At that hearing, you would have the right to have the prosecutor prove the allegations by a preponderance of the evidence. Now, if you're found to be in violation of your terms and conditions of probation, you would be resentenced on your original offense. You were originally convicted in this case of possession of the controlled substance methamphetamine. That is a felony punishable by up to 10 years and or up to $15,000. One moment. In this case, you were originally sentenced to 365 days of jail. That was issued on July 24th of 2023. Now that I'm sorry, and these are 3 technical allegations, which means if found guilty of all 3, the court could sentence you only up to, or add to your sentence up to 45 days. Now that I've told you what the allegations are, what your rights are, and your possible consequences, I need to see how do you wish to respond. The first question is, do you need the court to appoint an attorney to assist you?
Can I say something, Your Honor?
Well, I'm very concerned that if
Please?
you do, well, hold on, let me just say something first. I just want to remind you that I'm not going to ask you any questions, and any statement that you choose on your own to make could be used against you. Now, I don't know what you're going to say, but you've only asked me permission to speak. You may speak.
Your Honor, that alcohol bottle that Mr. Stapleton found is the alcohol bottle that was my mom's. I had it sitting on my dresser. That wasn't, I don't drink. It was my mother's before my mom passed away. And I tried to tell him that.
All right. And when was it that your mother passed away, Miss Rourke?
2022? Or no, wait, 2021.
Well, I just
I've
asked
had
that
that alcohol bottle ever since.
All right. I'm very sorry for your loss, and I understand how those losses can continue to stay with the person. All right, so clearly, your request is to enter a not guilty plea on your behalf. The court will do so.
I don't want to I want to enter a guilty plea. I just wanted to let the court know that that was what that alcohol bottle was, and I don't deserve to be in trouble for that.
Okay, well, hold on, Miss Rourke. I need to go back and explain something, and that's all right. First, again, I remind you that you do have the right to have an attorney appointed to assist you if you choose to ask for one. Now, the question here is first if you want an attorney, and then if you tell me you don't, then I can ask, do you wish to have it set for a contested hearing, or do you choose to plead guilty? Now, if
I
you
plead
choose to,
guilty.
let me get through everything to make sure I do it appropriately for you. If you do plead guilty, I'm gonna ask, are you gonna plead guilty to all three? Now, if you do plead guilty, you'll be given up that right to have that contested hearing, the right to have an attorney appointed to assist you. And that attorney could help you both at the plea, making a decision about what to do, review the evidence, negotiate the case with the prosecutor, and represent you through the hearing and sentencing. But again, if you choose to represent yourself, the Constitution does allow you to do so. Now, if you plead guilty, if you don't plead guilty to every charge, then the prosecution and the Department of Corrections can still have a hearing on that other charge. So for instance, if you did not, if you do not plead guilty to, say, the alcohol charge, then they have the right to continue. In which instance, if you wanted an attorney to assist you, I would make sure that you got one. Now, by the way, having an attorney appointed is not going to make anything go faster or slower. We would most likely be back on the record, I think probably tomorrow, maybe Wednesday, because I do not have any trials this week, which means it's not going to delay the case if you ask me to give you a lawyer. I'm just going to go back again and ask you one more time. Do you wish for me to refer the matter for the appointment of an attorney?
No, I know I've been bad. I did good for the whole year, so I know I deserve it.
Well, let's do this,
I
Miss
swear.
Rourke. Okay, hold
I
on.
plead guilty.
Okay, hold on. I'll get you there, Miss Rourke. Please raise your right hand if you would, please. Thank you. Jennifer, do you hereby swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Now, Ms. Rourke, again, you understand that you have the right to have an attorney appointed to assist you, or the right to hire your own attorney. Do you understand that?
I do.
And you understand that you have the right to have a contested hearing and make the prosecutor come in and conduct a hearing and prove guilt beyond a preponderance of the evidence? Do you understand?
I do.
Has anyone made any promises, threats, or inducements to force or compel you to plead guilty to these charges?
No.
Has anyone, and sometimes people will talk to their probation officer, and that probation officer may suggest what he or she might ask for, but has there been any promise to you as to exactly what the sentence would be if you pled guilty?
No.
And are you waiving your right to a counsel today of your own free will?
Yes.
Are you waiving your right to a contested hearing also of your own free will?
Yes.
As to the three counts, Ms. Rourke, how do you plead?
Guilty.
Wait, hold on. Ms. Rourke, hold on. I did say hold on before you stated your sentence. I'm sorry, your plea. Let me ask this question. Mr. Stapleton, how many days of credit does Ms. Rourke have?
Be 308 today.
Ms. Rourke, again, I stopped you before you entered that plea because something entered my mind. And I want to go back because I don't know what's going to happen or what my sentence would be. However, because you have already served 365 days, although you did, hold on. I sentenced you to 365 days. You served so far up to 308, which means you received all of your good conduct time, which would be up to 60 days, which means if I give you a sentence and I sentence you even to, well, hold on. I can't do that either because it's not, I can't send her to prison under third technical.
No.
Yes. Hold on, Miss Rourke. I need to take a look at this, a recently revised court rule. Sorry for taking so long, but I want to make sure we get this right. And 7714B, 1 second. Yeah, all right, thank you. According to MCL 771.4B, parenthetical 4, the court cannot give a prison sentence after only 3 technicals. Actually, it says I can't terminate probation, but if you send somebody to prison, you're terminating probation. So, all right. She hasn't had any other PDs in this file?
Not in this file.
No. All right. Miss Rourke, again, how to the 3 counts, how do you plead?
Guilty.
Or the court can accept your plea and must take in some facts. Miss Rourke, is it true that on or about March 7th, you were found, March 7th of 2025, you were found to be in possession of a pipe or paraphernalia commonly used for smoking methamphetamine?
Yes.
Is it also true that you tested positive on or about that date for the use of methamphetamine because you had
Yes.
previously used? Okay, because you had previously used some, is that correct?
I did, Your Honor.
All right. And is it true that you also were found to be in possession of some alcoholic beverages? I think you described it as a bottle of alcohol. What kind of alcohol was it?
It was a Tennessee Jack whiskey bottle that belonged to my mother. I really honestly didn't know I'd get in trouble for it because I haven't had it. I've had it and I've never gotten in trouble for it before.
All right, I don't know, but all I know is the court takes judicial notice of the terms and conditions of probation. Hold on. I'm taking judicial notice of the terms and conditions of probation that were signed by me on July 26th of 2023, and then acknowledged by the defendant on March 18th of 2024. I also find that the defendant's waiver of rights is made freely, knowingly, and voluntarily. The court further finds that the information provided by Miss Rourke under oath on the record, in addition to the terms and conditions of probation taken notice of by this court, satisfy the required proof for counts 1, 2, and 3. Therefore, the defendant is found guilty of those 3 counts. Mr. Stapleton, do you want to make a oral, or would you like to add some? What would you like to do?
Oral would be
All right,
appropriate, I believe, in this case.
Miss Rourke, you have the right to be physically present here in this courtroom at any time you are sentenced. Do you wish to be here, or will you allow us to do sentencing right now with you appearing via Zoom?
You can do it right now, Your Honor.
The court takes notice that the report rules allowing video conferencing are appropriate. Mr. Stapleton, you don't really need to say a whole lot since there's nothing I can really do, but go ahead.
Yes, Your Honor, this is a difficult situation. This is the defendant's first violation.
Right.
She really has done fairly well. I'll give her that for the last year.
I will say, Ms. Rourke, I was shocked to see your name this morning only because it reminded me that I hadn't seen you in a while, and I'm really glad to see that you've been doing well. Seriously. You know, for a while there, you were in and out a little bit, but it'd been at least a year. Well, obviously, it's been at least a year. So I compliment you on those positive progress. Keep going, Mr. Stapleton.
Thank you, Your Honor. Defendant's original sentencing guidelines were 10 to 23 months. The defendant was originally sentenced to 365 days jail. She currently has 308 days credit. she was sure the probation term she was given.
Let me take a quick look here. Yeah, 24 months. Looks
Okay.
like it should be done in July.
Okay.
Yeah, July 25th.
Okay. The defendant, like I said, is out of jail credit. So there's not a whole lot we can do in this case, I believe. I don't think we can take away good time credit for,
No, I got it. What do you think I should do with probation? That's really the issue.
I think we should continue probation.
Right.
Fines and costs be preserved. She has yet to pay anything on the fines and costs. Continue probation, and then we can keep her on until that July date. 308 days jail, 308 days credit.
I'm gonna give her, all right, I'm gonna give her the 365 with 308 days credit, which
Okay.
means she's already maxed out the sentence anyways.
That sounds good.
Miss Rourke, you have the right to make a statement before I give you a sentence. Let me explain though. I can't give you any more jail. So you're gonna get let out today,
Oh my God.
all right? By law, I have to. It doesn't make any sense, but by law, I have to. Do you wish to say anything?
Yes, I do, Your Honor.
Go right ahead, ma'am.
Judge Elmore, no, in March when I got out, I was doing really good. I was doing awesome. I had been clean for 1 year and 9 months. I did make a slip, and it will not happen again. And I appreciate you for making me learn.
All right.
You taught me a lot.
I hope so, Miss Rourke. Courtrooms are not always about, and judges are not always about punishment. It's always about balancing. That's why we look at punishment. We look at deterrence. We look at protection of society, but we also look at rehabilitation of the individual, because every person's life has value and it matters to this court, and I want to see you improve. Okay.
Thank you.
Well, Miss Rourke, I want to make sure you understand something, and I do not at all intend this to be considered a threat, because so far you made it 1 year without getting in trouble. That's great.
I'm honestly
the law-
appreciative of myself.
All right. Well, the law says, and this is kind of odd, because of your probations and this being your what's called only your third technical, the law says I can't give you any jail. It's kind of funny. If you had one more violation, then I could have sent you to prison. Now, that's not a threat, but I want you to know between now and July, you want to make sure that you get back on that right path, that you are continuing to stay off of controlled substances, that you are continuing to improve your own life. Okay, ma'am?
I sure will, Judge Honor.
All right. The court therefore sentences the defendant as follows. The court preserves all fines and costs, continues probation as previously set by this court, sentences the defendant to 365 days with 308 days of credit. Miss Rourke, as long as you have received all your good conduct time, the jail should give you the 60 days, which means you should be let out today. Okay? No, don't worry. I gotta sign some paperwork and get it over to them. All right, so it should be though today. All right. All right.
So I should
Miss
go
Rourke?
home?
Oh, hold on. Well, I don't care where you go as long as you don't get in trouble. I just want you to know this, Miss Rourke, you have the right to appeal your conviction and sentence. That is typically done by filing a claim of right to appeal. However, based upon the original plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want this court to consider appointing an attorney to assist you, you must let me know within 42 days. Do you understand,
Okay.
Miss Rourke?
Yes, sir, I do.